Hi everyone, happy Halloween. We are on to week 12. For this lecture, we are going to cover our readings and topics from week 11, and we are continuing on with our topic of hearsay. So this week, our readings covered two more hearsay exceptions, one which we touched on at the end of last class, which was the business record exception. So today we'll go into a little bit more detail on that exception as well as the public records exception. The two are very similar and cover a lot of the same writings, but do have some distinctions. So continuing on the business record exception. So to recap this from last week, these are written records that are offered to prove the truth of the matter asserted in the record. Anytime with a hypo on your essays, if you see a writing, think double hearsay, and for the writing itself, think it's probably going to be a business record exception. That's at least one of the hearsay exceptions you want to bring up. So there's 5 factors when we're dealing with the business record. So the first factor is that the record was made within the regular course of business of the business and by someone with knowledge. So it can't be made by just anyone. It needs to be made by someone with knowledge. The second factor is that the record itself needs to be kept in the ordinary course of business. So if you have a scenario where, sure, a business might make these records, but maybe they don't keep them, maybe they throw them away. If they've only kept the record in this case because of litigation, then you might have a problem. You need to be able to show that the business keeps these records within their ordinary course of business. The third factor is that the record or the writing needs to have been made at or near the time of the act that it's recording. So they can't, now that there's litigation, make a record of something that happened in the past. The record itself needs to have been made, again, at or near the time of whatever it's recording, and then kept up until now when we're at litigation. The fourth piece is that the record needs to be admitted at trial by a qualified witness who testifies to how the record was prepared and made. Sometimes this is called a custodian of the record, but it just needs to be a qualified witness, someone who knows how and why these records were made and kept. And then the fifth factor is that the record has to be trustworthy. The federal rules and the California rules handle this fifth factor a little bit differently, which I'll get into on the next slides. So this trustworthiness is an important factor. It'll be difficult to find facts about that within your hypo, so you'll need to address it, but be saying things like, if it shows trustworthiness or if the party can prove it's untrustworthy. But you do still need to know that this is one of the factors of the rule. So in the federal rules, it puts the burden on the opposing party to introduce evidence of a lack of trustworthiness. So if you have, let's say, the prosecutor is introducing the business record, they don't have to actually prove that it's trustworthy. It is one of the factors, but they don't have to give specific evidence that it is trustworthy. It's on the opposing party to introduce evidence that it's not trustworthy. And then we compare that to the California rules, where the person introducing the record actually has to show that the record is trustworthy. And so if you're in a California court or an essay where you're dealing with California rules, not only do you know those 5 factors, but when you get to number 5 with trustworthiness, you would want to say, in our hypo, there's no specific facts showing that the introducing party is showing that this record is trustworthy, and so it might not be admissible without that additional foundation of why this record is trustworthy. So a question, if we're dealing with a business record, what happens if there's the lack of an entry in a record? Is that itself an assertion or a hearsay statement? So for example, if there's a record of payments received by a business, so this is something that they regularly record, any payments that they receive. What if there was the lack of a payment? Is that lack of payment in and of itself an assertion that no payment was received. So that's something that you could say at trial. Here's evidence that no payment was received. And the answer is yes. The lack of an entry can be an assertion and therefore hearsay. So moving on to the public records exception. So this is again dealing with writings, with records, but they're specifically public records. So the FRE for this is 8038, and these are writings that record the public office's activities. Or number 2, matters that were observed under a duty to report. Number 3, factual findings from a legally authorized investigation. And then number 4, these records also have to show that they don't lack trustworthiness. So going back to factor number 2, matters observed under a duty to report, this specifically in this federal rules, this is excluding law enforcement observations in criminal cases. And what that means is basically criminal police reports. So under this hearsay exception, under the public records exception, it specifically excludes criminal police reports. If we look down to factor 3 here, it does include potential civil cases or criminal cases against a government. So if you have some kind of investigation happening in a civil case, it might be some kind of police investigation, but it's being used in a civil case, that might be okay, or specifically used against the government in a criminal case. And I'll go into a little bit more detail on what this means for police reports, because it has come up for a few folks as questions. And so we have the California rules here. Again, similar factors. The record needs to be made kind of within the scope of the duty of the public officer or employee, made at or near the time of the act or event or whatever it is they're recording. And we need to have those indications that the record is trustworthy. For this public records exception under the California rules, there's no requirement that a qualified witness testify to the preparation. So that's different than our business record exception, who does need that qualified witness to testify. So what does the public records exception add to our business record exception? Why do we need both? So many public records are also business records, right? It's a business, they're recording the things that they're happening in their business, in the public office. They are very similar since the government is a business. However, this exception goes beyond what the business record can do. So it covers matters that are not regularly recorded. So for example, a public official might make a once-in-a-lifetime observation about nuclear damage. This could be a public record. In the alternative, it wouldn't fall under a business record. This statement or this observation is not something that's happening in the regular course of business and government. But we have this public records exception so we can get those kind of once-in-a-lifetime statements or something that's not happening regularly but are still important. So our rationale for this, and again, I think similarly to a few other hearsay exceptions, we might not agree with the rationale. But regardless, the rationale behind this is government officials are, we think, considered more trustworthy than your average person. They have a legal duty to be accurate in what they're reporting, and so we're going to believe their public records more so than we would believe something that you or I just write down. This is also just considered a necessary exception because public officials handle a lot of matters. They might forget facts if they're not writing down these records, and those facts are important, especially to lawsuits. And so this is kind of the only way we could bring them in. Your average public official might not remember all of these specific details that could be really important in a lawsuit just because of the volume of things they're dealing with. So going back to police reports. On its face, police reports look like they could fall under the business record exception or the public records exception, except for, again, the federal rules 8038 specifically chooses to exclude police reports for criminal cases. The worry here is that prosecutors would just charge and convict defendants based on police reports. They wouldn't actually have to prove their case. If we were just taking a police report for the truth of the matter asserted, whatever a cop or a police officer wrote in their report could then be used directly against the defendant as truth. And you could see how that would be very prejudicial to criminal defendants. However, courts have since, across the country, rejected just this blanket approach of excluding all criminal reports. So it doesn't specifically fall under the public records exception, but you could try and get it admitted under a different hearsay exception. So some courts have found that, again, while a police report might be excluded under 8038, maybe it could be admissible under 8035, which is our recorded recollection. You would have to go through the analysis of a recorded recollection. It would be something where the police officer doesn't remember what they wrote down. You'd have to go through that analysis, and it might be that only parts of the police report are admissible or some of the statements within it. Criminal police reports have also been used to refresh officers' memories on the stand. So that's not actually having it admitted into evidence, but you would let the officer testifying read his police report, and maybe that would jog his memory, and then he could testify on the stand to whatever was in the police report. But he would be testifying based on his own memory after he remembered after reading his report. So when you're dealing with police reports and hypos on essays, just be cautious of concluding that the report will be admissible against a criminal defendant. Even if you think it might fall under an exception, again, with our balancing test, you want to think of how prejudicial these police reports can be to the defendant. You can always have a police officer testify about what happened. That's okay. But when we're dealing with hearsay exceptions, this out-of-court statement, this out-of-court report, we want to be really cautious of finding that that report can be introduced for its truth. Not only is it maybe not falling under an exception perfectly, this would also be a confrontation clause issue. Our criminal defendant isn't being given the opportunity to cross-examine the police officer if it's just a report, which again is a big deal in our criminal cases. We want that police officer to be there and have the defendant be able to cross-examine him. So we have a hypo about our business records. So we have a collections action by a company that leases cars to businesses. The plaintiff offers a computer printout of its accounts receivable. The software is a widely used database program. The sponsoring witness or the qualified witness testifies that she doesn't know anything about the software design, but she uses the software and she knows that it is routinely used in their business. She testifies that the printout is a standard bill that's sent to customers, and that the information within it is generated from data input by the sales consultants who deals with the customers. And it shows the periods of the rental, the agreed terms, the amounts due, and the damages, if any, observed when the car is returning. And then at trial, we get an objection that she doesn't know how the computer works, and so she's not a qualified witness to be able to introduce this record. So if that's our objection, what would our ruling be? So this ruling would likely be overruled. Computer records like these are treated the same as paper business records, and it's okay if she doesn't know how the software works. She's still telling us about how the record is made and what's included in these records or reports, and she would qualify as a qualified witness. Another hypo. So defending an action for a breach of contract after it repudiated a contract with a car lease customer. The leasing company offers a witness who testifies, I am a computer expert. I created a program that determines whether high rates of auto malfunctions were due to the customer abuse or to manufacturer error. This program revealed that the B Corporation had an unusually high rate of abuse, and that is why we terminated our contract with them. This is a program that is routinely and regularly used in our business. We get an objection at trial for no foundation. And then what would our ruling be in this case? So likely this objection would be sustained on that foundation alone. With expert testimony or novel techniques like what we have used here, some new program or new software that's used by experts, we need to show that they're reliable. Here, the computer program is not just performing a routine function of the business, it's doing something beyond that. It's getting new data that is not being widely used by other similar businesses or companies. And so you essentially now have expert testimony. This is some new novel technique that a judge isn't going to know about, the jury's not going to know about, and it's not the same as just, records showing payments received. It goes beyond that. And so you would then need to show more foundation of why that technique or new process, why that is accurate, and why a jury should believe it. Another hypo, let's say we have a criminal action. A police expert testifies that using a computer database, he keeps track of crimes. When the defendant moved into a neighborhood, the crimes involving the defendant's normal method of operation started occurring. And then when he was arrested, they stopped. So objection or question, on what grounds might there be an objection here? A couple different options. So this could be a confrontation clause issue. So the statements from which the expert drew his conclusions were this program that they're using to track, the criminal data. These are arguably testimonial. This is a police officer tracking crimes, and that information is likely going to be used in litigation. Kind of why else would we have it unless you are then trying to arrest these criminals and charge them with the crimes that you're tracking. You could also have a hearsay objection. So the crime reports on the records are based probably from declarants with no business duty to report anything, or from police officers or police records that would be barred by our public records exception. This could also be improper character evidence. We're essentially saying because there's crime happening that we think this defendant does, he must be guilty of that crime now. So that's our conduct in conformity, 404B character evidence issues. We also have a reliability or validity of this new technique objection. It's not really explained how this tracking program works, so we would probably need more foundation, either from the person who made the record or the police officer, to explain to the judge and the jury, what this program does and why we think it's accurate or reliable. And so we are going to go through our casebook hypos. What I'd like you to do is to pause this video, take about 30 minutes, more if you need, and go through our casebook hypos, starting with number 1 on page 452. I'll then come back and go through the answer explanations, but like we do in class, it would be good if you took the time now to